Hello, welcome to the ESPC Show. As ever, it's Paul and it's
Megan. Today we are going to have a quick intro, and we don't want to spend too long introducing our guests because they've got a lot to say and it's really interesting and valuable. So we had Dianne and Kimberley on from Watermans to speak all about marital status, so buying unmarried, but also the opposite end of separation, divorce, and what happens with your property. So, yeah, quite a big topic.
It's incredibly informative, though.
Yes, it really is.
And we learned so much in this episode. And there's bits of it that you're probably thinking, do we want to face up to these things? Death, divorce, all these other things. But it's so valuable. And as I say, we didn't realise the amount of people out there haven't got a will. You find out why you should. Lots of things to cover. It's definitely worth a listen.
Yeah, so without further ado, here's our chat now.
Today we are joined by Dianne and Kimberley from Watermans, and we'll get you to introduce yourself in a moment. Then the questions might get slightly harder, but not too hard. And we're going to have a good show today. We're just going to have a chat, and we're going to chat about...
Yeah, we're going to chat about how marital status can affect you during your property journey. But I will leave the intricacies of that to the experts.
Absolutely.
So I don't know if we just want to kick off. Dianne, Kimberley, do you want to introduce yourselves?
Yes, thank you. My name's Dianne Millen. I'm the Head of Family Law at Watermans down in Leith.
I'm Kimberley Mackay and I'm Head of Private Client. For those who don't know, Private Client covers wills, trusts, executories and powers of attorney.
Brilliant. And that plays a bit of a part in some of the answers today, doesn't it? The whole... I'm spoiling it already. We're going to get into it. Shall we just start? We'll just get into the question saying we'll see how we play out from there.
Yeah, so I think the reason that we were interested in chatting to you guys was that there's a lot more people getting onto the property ladder in an unmarried couple. That might be friends buying together, siblings, or romantic partners. But we just wanted to ask, first of all, how are you seeing that? How frequently do you see unmarried couples purchasing together?
Yeah, I think in line with what we know about society generally and see around us, there are more and more cohabiting couples coming in and wanting to purchase property together. And from my point of view in the law, there would be a difference between two siblings or two friends or flatmates buying together and two people that are in a romantic relationship. And that could be of any kind, or any configuration of people or anything like that. But it's that intention to live together as if you were partners or spouses that makes a difference in law.
I suppose then, just thinking about that then, and you are at that point when you think we're going to buy, be it in a relationship or even friends, as you say. I think just with the financial situation, we know friends are buying. What should people be thinking about before buying a home together then?
From my side of the house, it's really about the investment that you make in that property and who's taking on the debt by way of the mortgage. Because if one of you is putting in a bit more than the other, which isn't unusual, depending on what's happened in life up till then, or even if somebody's parents are kicking in a bit, which we see quite a lot, as you can imagine, then people might assume that if things go wrong further down the line, then they'll just be able to get their money back out of the property. But that's not always as simple as we'd like it to be. And long story short, often the best way to deal with that is to set out everything in an agreement before you actually complete on your purchase, so that everybody knows if things come to an end, then this is what will happen to that investment and how that will be dealt with. So that gives everybody clarity from the get-go. If you don't have that, and I also am consulted by people who are at the other end of that process and they're splitting up, and without going into a lot of technicalities, it is not always straightforward to get your deposit back in those circumstances, certainly not without going to court, which is not, and nobody wants to have to do that. So I suppose the takeaway is, if you are looking to purchase with a partner in particular, and you're putting in different amounts or even only taking the mortgage in one of your names, for example, you need to have a chat about looking ahead to what you might need to do.
Even though we know that, the chance are it won't happen, and it is a horrible prospect. You've just got together, you're buying everything. Well, what if it all falls apart? But as you say, there's really good reasons for doing that. And is that a legal agreement? Is it just a letter you both sign? What is that?
It's best if it's drawn up by a solicitor, and we can only act for one person in the couple because the other person ought to get their own advice from somebody who's independent of them. And I know it's not the most romantic thing. I am the romance killer in the office. There's no doubt about that. So, but yeah, we have the agreement needs to be tailored to each individual couple, but there are certain things they should all cover. The difficulty is if you just email each other or you have a verbal agreement, even being able to prove that later on is going to be a difficulty, and potentially that might not be enforced if there was a challenge to it. Whereas if we do that properly and get it set out for you, my hope for all my clients is it just gets stuck in a drawer and they never have to see it again.
Exactly.
But if they do, it's there.
You mentioned about the prospect of somebody putting in the deposit and the mortgage being in one person's name, but potentially, you know, the couple are both splitting the cost of the mortgage. What kind of happens in that situation?
That's a bit more of a wet towel round the head job for me, to be honest. Usually if you're...
You've got a lovely turn of phrase.
I mean, I like seeing it, don't get me wrong, but it's a bit more challenging because usually then only one person will be taking the title. And if you're putting in thousands of pounds of your own savings and you're not taking any title, you're really in a vulnerable position legally then.
Title being that you can't evidence that you actually have a ownership in that is...
That's right, you don't have a share of the ownership of the property, and people don't necessarily understand the implications of that. And an agreement like the one I'm describing won't change that. It doesn't give you ownership of the property, but it will give you some certainty about getting your money back at the end of that relationship if that happens.
I'll cover perhaps the more morbid side of this,
Yeah.
which is another really important thing to think about when you're purchasing a property, which is to make sure that you've got a will in place. And that goes for single people and married couples and unmarried couples and other people who are buying together who are not in a relationship. The important thing is that you do think about worst case scenario, and you think, if something happened to my partner, can I afford to keep living in this property and continue making the payments, and is that going to work out? And it's one of the areas that people tend to ignore because it's not nice to think about it. You don't want to have to think about yourself dying or your partner dying, but the reality, if you don't plan for it, can be quite brutal. So that's one of the things we would definitely recommend. And at the same time, we usually recommend people have a power of attorney in place, just in the event that them or their partner isn't able to make decisions for themselves. That's what power of attorney does. And it means that the other person can continue to make sure that the property's being looked after and the payments are being made on behalf of that person who can't do that. So the will and power of attorney are quite well put together to be done at the same time. But the rights of married couples and unmarried couples in terms of inheritance are very, very different. So it's so important, particularly for unmarried couples, because there's no automatic right in law. So if you're married and one person dies, then there are automatic rights of the spouse. There's no such thing for unmarried couples, and it does require a court action within 6 months, whereby you might get something that you think's appropriate, but you might not, because the sheriff ultimately will decide what's appropriate. So the safest thing for yourself and for your partner is just to get a will done, plan for the worst and hope for the best.
Sure, no, well put. And as I say, I think it's almost like a pension. It's something you never really think about until you get nearer the time when, as you say,
you need it.
Go early on these things, isn't it?
Yeah.
At first time I was sitting down talking, I mean, yeah, I was going to ask you if you've got a will, Megan. You can ask me. I have. And I think equally it's about keeping it up to date as well, isn't
Absolutely.
it, really?
We usually recommend a will review every 5 years.
Oh, right.
Or if you've had a change in circumstances. If you're unmarried and you then marry, that's not a reason to change your will, but you should definitely review it. Divorce is absolutely a trigger for a new will.
Have you ever had a scenario where somebody hadn't updated and things had changed and suddenly the wishes... Can that be appealed against, or is it, sorry, it's in black and white? That was...
Generally not.
Okay.
There are rights of spouses. It's called prior rights and legal rights. So there are certain people, being spouses and children, who can make a claim on a person's estate, but it's only on the movable estate, which does not include property. So if you, for example, had a will in which you said, I leave my property to the cat and dog home, and you've left your spouse out, there's nothing they can do about the property side of it. Perhaps on the cash side, but not the property. So a will is an absolute way to ensure that the person you want to inherit your property or your share in the property can do so, and it cannot be challenged unless... It can be challenged, actually. I shouldn't say that, but it can't be challenged because you feel like you've been left out.
Sure. Okay.
And I think that's another important point in relation to divorce, because I will normally say when I meet a new client who's divorcing, or indeed separating but primarily divorcing, you should speak to my colleague about your will, because a lot of people have got wills leaving everything to their spouse and vice versa. And the divorce process can take a bit longer than people imagine, and if something happens to you over that period of time, your existing will would still be relevant. It wouldn't automatically terminate until you divorce. Most people in that position don't want their spouse to inherit because they are separating, but the only way to rectify that is to make a will. A lot of people will say, I want to get to the end of this process before I think about that, and I can totally understand that, but it doesn't actually protect them over that period of time, and that can have very serious consequences.
Absolutely. Wow. Okay.
So I guess that kind of moves us on to the kind of separation side of law. Not the happiest subject matter, as you mentioned, but in terms of if people are getting married, we were just chatting before about prenuptial agreements. I wasn't 100% sure what the legalities were around that in Scotland. How legally binding are they?
Does it only work in LA? And if you're a Hollywood film star?
Well, that's the thing. Everyone thinks prenups are for the rich and famous, but they're not actually. They're for anybody who's got any significant assets before they get married. And it's quite different between Scotland and England as well. English prenups are like the phone directory. They've got a lot in them. And in Scotland, they're a bit more restricted, but they are absolutely valid, and I would expect a court to enforce them. And really, the main purpose for most of the prenups I deal with is that someone's coming into the marriage with significant assets. They may have inherited them from the family, or they may have acquired them before the marriage, especially if it's a second marriage. And if you get married and those assets just sit there and you don't do anything with them ever, then they're not part of the pot if you split up and need to be shared. But that's not how real life works, because people will sell the property and buy another one, they'll cash in shares, or they'll use money in a bank account to buy things. And the more your premarital money gets mixed in with the joint money, the harder it is to set that aside if you do divorce. And usually the purpose of a prenup is really to ring fence those assets, and they're off the table, generally speaking. So if you were subsequently to divorce, the agreement says they will not have a claim on X, Y, and Z that you came into the marriage with. And mostly people will agree that that's fair and reasonable for each other. It applies to both parties, so both people can protect the assets they're bringing in. If you don't have one, it doesn't mean that you can't try to make that argument that those should be excluded, but you're then putting yourself on the mercy of the court, and as Kimberley said, that's not a good place to be.
Sure. And same rules apply, independent advice, both people need to sign it. Is that how it works?
Yes, and that's actually critical to the question you asked about enforceability, and that's why we would always want our client's spouse or spouse-to-be to take their own independent legal advice, and indeed I act for people in that position referred by other solicitors, because that means they know what they're signing, they understand what it means. They can't then say that it was sort of put under their nose the morning of the wedding, and if you don't sign it, then it's all off. And in fact, the length of time you've got to consider it is also part of the enforceability of it. So getting that organised in good time before the wedding, having time to take independent advice, and the person fully understanding and not feeling pressured are all part of the picture in terms of being able to rely on it later.
I'm just picturing it, after you've been married, you sign the thing, and then, whilst you're here, can you just sign this as well?
No, absolutely. And actually, if you'd missed the deadline, you can do it after you're married, because we would just call it a post-nuptial agreement.
Yeah. So it kills the mood a bit, I would imagine.
Yeah, but the problem with that is you've kind of lost your leverage, if I can put it that way, if you're the person with the assets. But I have had clients who have just, for whatever reason, not been able to get things over the line in time and have come back and negotiated it afterwards, and there's no legal reason why you couldn't do that.
Sure.
And is it something that a lot of people get? Do a lot of people get prenuptial agreements?
I am seeing more of them than I used to even a couple of years ago, and I think that's because knowledge is spreading, just so people see it in celebrity news and so on and think about it. And you do get a lot of inquiries about it. Doing the actual post-nup is it's a reasonable undertaking in terms of the document and the complexity. What sometimes worries people is that, if they put that in front of the intended spouse, how are they going to react? How are they going to feel about it? Because it does feel very mercenary. It does feel quite uncomfortable. And sometimes it's helpful for people to be able to blame the lawyer in a way. Say, my lawyer told me that I had to have this conversation.
And would you say that? But that's a really good point that you're making there, Dan. Is that saying we think a prenup in this case would be valid? I mean, as you say, that not that they're blaming you, but you would be pointing these things out, or would you?
Yeah, for me, it's about saying this will give you some clarity and certainty about what will happen in the future. And certainly, if your client is the person who has assets to protect, then you have to say, without this, there's some risk that you might lose those in a divorce or part of their value anyway. And usually when those assets have come from the family, there's a particular, people particularly want to hang on to them. Also, if you have children from a first marriage, you're more likely to want to protect those assets so that they can pass to their children, which is something that Kimberley would do. And so a succession review is part of what we would do in that situation.
Mm-hmm.
I think one of the things that's probably rings true for both of our lines of work is that a lot of clients think that they're not rich enough to have a prenup, and they think that it's for the rich and famous. And a lot of people will say to me, I don't have anything to put in a will. And I'll say, do you own a house? And they say, yeah. I'm like, there you go then. You absolutely have a very valuable asset that needs to be protected.
Mm-hmm. And pensions and things like that, death and service, that sort of thing.
Pensions generally fall out with the estate, and don't tend to be dealt with in terms of the will, but not necessarily. So that's something that we do as part of the will process, is that we make sure that you've got all of your ducks in a row with all of the things that might be required or might become valid on your death.
Mm-hmm. Okay.
And I think one of the other, I agree with that, one of the other things people think is that it should all be relatively simple. You can sort of write a letter and that will dispose of all of these issues. And when you say actually it's going to be an agreement and this is how much it's going to cost, and there's a lot of moving parts to it, that can be a little bit off-putting. But it's just that what you have to do to make sure that your wishes are followed, whether that's in separation or whether it's on death, and there's a reason that we have to put it in that way. And, once you've done that, you've done it. You don't have to keep going back to it in the case of a prenuptial agreement. Although if things change, for example, if you leave the country or if you have children or you acquire other substantial assets through inheritance, you might want to review a prenup just as you might review a will. But, I mean, it has to be done a certain way for it to work, and we just have to accept that, I think.
Well, I was just thinking, the people who might be listening to this might be unmarried couples who are considering a move in together. It might be people on the other side, maybe looking at separation. So I wondered if you had any practical advice. First of all, we'll speak about anyone looking to move in with a partner. What kind of advice would you give somebody considering that step? What's the first thing they should do?
Probably the first thing they should consider is how the expenses are going to be dealt with and whether that's going to be an equal contribution or not, because that might determine where they go in terms of the advice that Dianne might give for a prenup. And again, that bears an importance into their will as well, because again, if there's an unequal contribution, that might affect how their wills are going to be set up.
If I'm consulted by someone who's thinking about moving in together, what I would normally cover, firstly, as you've said, is how's this going to work financially, who's putting in what, are you getting a loan from parents, do you already own a property, are you selling it, how are you going to arrange that, and how are you going to deal with the mortgage and so on, and what's your agreement. But I would also want to outline for them what the, if you want to call it, the default legal framework would be. In other words, what would happen if you don't do an agreement? What might happen if you separate? What might happen with your deposit? What would you need to do to resolve the problems that arise? Because one example is often when people separate, one of them wants to buy the other out because you don't, that's an obvious thing to want to do. It means you don't have to sell and somebody wants to stay there, someone doesn't. If you're cohabiting and you're not married, then you can only achieve that result if you both agree to it. If you're married and one of you wants to take over the property, you could ask the court to make an order about that in a divorce, but you can't do that as a cohabitant. Therefore, having an agreement that says, for example, if we split up, I'll have the option to buy you out, means that you have that mechanism available to you. And I think if people don't understand where they would be without an agreement, then they can't really make an informed decision about getting an agreement. So it's about making sure they understand what may happen. Of course, we can't be certain because law changes, and if someone splits up in 20 years' time, I don't know what the law will look like then, but we can only do what we can do with that. So understanding your rights and the implications of those, and also the rights you don't have, I think are really important in making a decision about your purchase or any agreement that you might have.
That's really interesting. And just going back to the previous point there when we were talking about contributions, I mean, I'm loath to use the word uneven contributions because I'm sure people pay what they can pay in, but let's say somebody's paying the mortgage and somebody is maybe paying the bills, and let's say the mortgage is 4 times the bills. When it comes to be sold, if people are going the separate ways at that point, what would be the default position, or is it so many other considerations there? Is that not a easy answer to give?
One of the things I say all the time in my working life is, well, that's a wee bit complicated, but let's explain it. So that's one of those. A couple of things are, broadly speaking, let's put aside an agreement for now. Let's say that people don't have it. So if you've cohabited for, say, 10 years and you've had that kind of arrangement, what we would look at is what your financial position was at the beginning of the relationship and at the end of the relationship. And if there's a significant economic imbalance between you that isn't sort of evened up by another contribution, it may be that you have a claim to effectively be compensated for that. And a good example of that would be, for example, if one of you had worked in a business owned by the other but hadn't been paid and didn't own any of the business. So, if you hadn't been doing that, you would have developed your own career, so you've lost out. So that's a possibility. And if you have that claim for compensation, you can make that to court within a year of the relationship ending. There are complexities around doing that, and there are relatively few cases that reach the court because of that. And you mentioned a situation where one person's paying the mortgage and the other person's paying the bills, and that absolutely is how a lot of people organise their affairs. The difficulty is it's much easier to evidence a contribution to a house by payment of a mortgage than it is to say, well, I paid for the groceries, I paid for the holidays, I paid for the
I
kids.
got that takeaway.
Yeah, because the court, you're in a bit of a catch-22 because the court expects you to provide evidence for any claim of that nature, but it doesn't want you to turn up with 25 pages of Tesco's receipts. And, the Supreme Court has talked about this and say, people don't run their affairs on the basis of I put in £29.50 there and you pay in £17.50 there. So if you're the person who's paid for the groceries and the holidays and the things like that, you're at a bit of a disadvantage in that situation. And I don't think there's an easy answer to that, but certainly...
Well, is the easy answer have something in place that, an agreement at the beginning,
It would be a little bit more difficult for it to cover that situation, because what you could do, and some people do, is you can say at the beginning, no one's ever going to have the right to make that kind of claim at all.
Sure.
But that's quite a drastic solution, although it has its place. One solution, and this is going to sound a little bit old-fashioned, is to get married, but there's lots of other different reasons to make that
Very
choice.
romantic.
Absolutely, as we've observed, I am the queen of romance. But I think it's very difficult to say to people you should run your financial affairs as if you were going to separate, because people aren't going to do that. At the end of the day, it's usually possible to achieve a compromise, because ultimately, although I've talked about going to court, most people try to achieve a fair compromise with each other. Even if you're separating, that doesn't mean you're going to go for the throat with each other, and most people are reasonable about these things, and ideally it can be resolved on that basis.
Sure.
This might be a bit of a silly question, but it's just
Never.
coming to my head. In terms of length of cohabitation, does that affect any... No, so if you've been living together for 1 year or 20 years, it doesn't matter if you're unmarried?
This is one of my soapboxes, so you're going to wish you hadn't asked me.
No.
A lot of people think that if you've lived together for X amount of years, you're common law married, as if you take on the rights and obligations of marriage. There is no such thing in Scotland at all. You are still living together at the end of that period. So for 2 years, 20 years, longer than that, your legal status doesn't change. I think if it's a longer relationship, it's usually easier to show that there's been an economic imbalance, because, so much time has passed that things will have played out in that way. But there's no specific legal difference between a cohabitation that lasts 2 months or one that lasts 20 years.
Right. And what's the definition of again, it's one of those silly questions, but I'm going to ask, what's the definition? I mean, is there a certain amount of days a week you need to be living there to be classed as living there, or is it if you're on the council side?
It's more about intention. So you're living together as spouses. So you have a romantic and physical relationship. You share groceries, cooking, domestic duties. You socialise together, you represent yourselves as a couple to other people. And there can be interesting sort of examples that are non-standard, like if somebody's working away during the week or somebody's in prison or things like that, and the courts have considered that, but it's primarily, I think, around the intention, because there is a difference between living together as partners and living together as flatmates, and those are the kinds of criteria that the court will, or a court would take into account if it was asked.
Sure.
The length of the cohabitation would be relevant for a claim on death, so the sheriff would take that into consideration. So the maximum claim that can be made by a cohabitant on death would be, the maximum award would be what a spouse would be entitled to, but I rather suspect that if the couple had been cohabiting for a very short time, it's unlikely that the sheriff would award the maximum amount. So it's even more important that a will's in place, because it's very, very uncertain what the sheriff might do.
That could be a real double tragedy, doesn't it? You know, if you were just 8 weeks into living together and
Absolutely.
something horrendous happens, and you know the view is, well, you weren't really that serious, you've just barely got together. You know, you can imagine
your whole world is turned upside down.
You're grieving and everything else. Heavens.
Such a simple thing to have in place, but very much overlooked by a lot of people for the obvious reason that thinking about that kind of thing is not nice, but it's so important.
And how complicated is it to get a will?
How long is a piece of string? No, it's most of the time for, you know, particularly for, you know, young couples coming in who are buying their first property and they've got a modest amount of savings and situation's quite straightforward. The will's probably likely to be quite straightforward. If you've got a couple who are doing a blended family situation in which they have children from previous relationships and they want to protect both the future inheritance of their children but also protect their new spouse in some way, shape or form, then you might be looking at something a little bit more complex, like a trust, a life rent trust, which allows the spouse to continue living in the property but ensures that the investment that they've made in the property falls to their children eventually. Otherwise, we can see what's called a sideways inheritance, where the assets pass from spouse one to the surviving spouse, and the surviving spouse then remarries, and the children of that relationship lose out entirely. And that does happen quite often. So these are the important conversations you would have with your solicitor when you're making your will, just to understand what your options are and make the best choice for your situation.
And never assume it's, you know, as you say, it's going to be automatically past where you think it is.
Yeah.
And what percentage, I don't know if you know the answer, but what percentage of people actually have a will? Is it?
I think it's about 40%. The last time I saw a statistic there. So not enough.
So work to do.
yeah, absolutely. And I think it's even rarer for younger people. You know, older people tend to plan this, or they have a bereavement of their parents, for example, and they start thinking, oh goodness, I should do my own will. But actually the time to do that is much sooner, and it gives you more options as well. The sooner you plan, the more options that you have available to you.
And would you say that people doing power of attorney were older as well? Because
Absolutely.
people don't think that they could have, people think it's about dementia or what have you, but you could have an accident.
And that's often what we see happen, is that you've got a situation where somebody's been in an accident and they're not able to make decisions, and the either the cohabitant or the spouse is at home trying to sell the property but isn't able to until either a power of attorney is done, or if a power of attorney cannot be done because the person cannot consent to it, it would then be down a guardianship route for a court action, which takes a very, very long time. So power of attorney is absolutely overlooked, and it's associated with old age, illness, but it's not just about that. It's like an insurance policy. You know, hopefully you never lose your ability to make your own decisions, but if you do, you know that life's going to be easier for both you and your family to keep things going for you.
Plan for the worst and hope for the best.
Absolutely.
Or just live the best life, you know.
And as you mentioned before, your advice was, if you wanted to kind of avoid all of this, was just to get married. Does getting married kind of negate a lot of these issues?
It's more on my side of the house that there's a different legal framework for married couples than there is for cohabitants. So I talked about, for example, being able to buy somebody out or get a transfer of the property. That's something a married person can do on divorce, but a cohabitant can't ask the court to do that.
Whilst it's in my head, civil partnerships? Or which side of the line are they on? Or are they?
Civil partnerships are, to all intents and purposes, marriages for these purposes.
Good.
There are a couple of tiny differences buried in the schedule of an act somewhere, and a couple of larger differences, but they're not relevant to these considerations. So, and absolutely, relationships and marriages of all combinations and possibilities are we see them and they're dealt with in the same way. So in terms of the legal framework, I think there's just more of it actually for married couples. The framework that we have for divorce has been around since 1985. Actually, that seems like a really long time now. But the fact it's still there, it's only been updated once in 2006, suggests that it's actually really workable. It is something that people find clear, and it usually produces fair outcomes. And really it's about taking stock at the end of a relationship, having a clean break and walking away with a fair outcome financially. And there are various principles that can be applied to make sure that that happens. But you have the ability to try to resolve things using different techniques. You can get that property transfer order that I mentioned. You can ask for a share of someone's pension if you don't have a pension or don't have sufficient pension. You can ask for an order for the sale of the property, although a cohabitant could do that as well. You can ask for a sum of money, a lump sum of money, or you can ask for maintenance to be paid to you on an ongoing basis. So you have a lot of tools, whereas cohabitants have kind of got the blunt instrument of if I've been unfairly treated or if I'm disadvantaged, I can ask for compensation. So there's just more to work with, I think, would be the way to see it on the ending of a marriage.
Okay, and in terms of if somebody's listening and they're potentially at the start of going through a separation and looking to get a divorce, what would you say in terms of their property rights? Where do they stand right now?
It's going to depend on lots of different things, like when the property was bought, in whose name the property was bought, who's paying the mortgage, who paid into the deposit, all of the things that we've been talking about.
Is there any change if somebody leaves the home? Does that weaken the position, or doesn't it matter?
It wouldn't have a significant impact on the overall financial settlement. It might have an impact on practicalities like seeing your children and so on. And of course, children are top of the list for everyone who has them if they're separating. There's a whole set of issues around that as well. But the first thing to think about, I think, is just to, and you know, obviously I'm going to say this, but you need to take advice from a solicitor. Just because sometimes people say, okay, I'm splitting up, let's put the house on the market, and they go off and do that, but then they don't realise that there's this bigger landscape of other assets like pensions and so on that need to be taken into account. And then when they get to the point of finalising the sale, they run into someone like me who says, wait a minute, have you thought about all this other stuff? So the earlier that you have that conversation, the more rights you'll understand. And we're not going to push you into running off to get a divorce if you're not at that stage. And we don't want to make things more adversarial or more difficult and negative. It's actually about trying to calm things down and be organised and rational about it. But it's best to understand the whole picture before you commit to anything like selling your house.
Good.
You asked earlier about the what the difference is of just getting married. From an inheritance point of view, anything that passes to a spouse is tax-free, regardless of the amount. So sometimes my advice to clients is when they're making their wills, if their estate's over the tax threshold, the simple way to avoid having a tax issue is to get married. Again, very romantic reason for tax reasons, but it's valid. It brings its own issues with Dianne's side of things, but it is definitely relevant.
Mm-hmm. What's the tax threshold? I know what it is, but what's the... It's
£325,000,
right.
And there are additional top-ups
Sure.
on top of that, depending on your circumstances. But 325 is what we call the nil rate band. So if your estate is more than that, then there's potentially tax to be paid at 40%.
Ooh, yes.
Yeah.
Eye-watering.
One of the things that I think is important, particularly for young couples with young families, is when they're thinking about whether or not they need a will, the answer usually is yes, you should do a will, but particularly if they have children, because it allows them to nominate a guardian in their will to look after the children if something happened to both or one or both parents. And that's something that's often overlooked because, you know, children are very, very important, as we know, and it's such a simple thing to do, to have in place.
We've spoken a lot about wills, and there is an obvious question here. I'm thinking mine's in the top drawer. Tell me, Mum, where it is. But where do you put your will? Do I give it to you? Do I keep it? Where do I put it?
So usually what would happen is you'd come into the office and sign your will, and then we would keep it in the safe, and we would send you a copy to keep at home. But you can keep your will anywhere you like. There's no central wills bank as there is in England.
Mm-hmm.
They've looked into doing it in Scotland, but it's not quite kicked off yet. So you can keep your will anywhere, but generally people will keep it with their solicitor and it keeps it safe. when you're purchasing a property as a couple or as two people, you can own the property jointly in one of two ways. One is called survivorship and one is called pro indiviso. Survivorship means that there's an automatic transfer on death. So on the death of the first person, that person's share automatically transfers to the other. It's automatic, it's instant, and there's no paperwork required for that to happen. Those types of agreements are quite rare now, for the simple reason that you don't get the flexibility that you do with the next option, which I'll talk about, which is called pro indiviso. So the survivorship destination we see in a lot of older title deeds, but it's not being phased out as such, but it's definitely rarer now because it doesn't give you the flexibility to say in your will, I want this person to get my share in the house. The survivorship would trump whatever's in the will. So generally speaking now, when people purchase a property together, it's purchased in pro indiviso shares. And your solicitor, when you're purchasing, should tell you about that. And you do have the option of asking for the survivorship, but as I say, it's very, very much, it's very rarely recommended. Pro indiviso means you each own a 1/2 share, and on your death, your 1/2 share will go to the person named in your will, or if you don't have a will, it will fall under the rules of intestacy.
Yeah.
And I particularly don't like survivorship destinations, and Kimberley will have heard me moaning about this in the office, because from my point of view, if you own your property jointly and to the survivor, then you separate, then if you pass away over the period of time that we're negotiating your separation and your divorce, it's not usually possible in a separation agreement to do away with the survivorship in a legal way. You've got to actually effectively transfer the property back to your joint names without the survivorship, which is a cost people don't want to incur. So protecting clients over the period between separation and divorce where there's a survivorship, you have the risk that the other spouse will get their half without it going through the process, as Kimberley has said, and usually that's not what people want. One of the other questions I get asked as well is, where do you put your separation agreement? Where is it stored, or your prenuptial agreement or whatever? And unlike Kimberley, we don't generally keep those for you, although we will if you ask them. And in fact, we can put it in the same envelope as your will, so it's not very tidy. But a lot of these agreements can be sent to a central register, unlike with wills. And basically, the register keeps the original and gives you a certified copy of it. And then you keep the certified copy with your other important papers, or we can keep it for you. But one of the benefits of that arrangement is that if you lose that or something happens to it, we can always obtain another copy from it. So if there's any doubt about an agreement, or you think you might have made one and you're not sure of the details, because that does happen, especially a long time later, we can get another copy for you, and you don't have to worry about losing the original. So that's usually what we do.
Don't lose your will, though, because that's a problem.
This could make a great soap opera, couldn't it? Or a great, the next season of Succession, I can feel it coming on.
Well, thank you both very much for coming in. That has been a really interesting and informative chat. I've really enjoyed that.
Yeah.
Well, it's not maybe not the happiest subject matter, but it's been very interesting.
It's important, as you say, the idea of going early and just say almost confronting these things well ahead of time and having that, you know, that painful conversation that you probably only ever have to have once, and it's agreed. And as you say, the heartache and all the things that would save in the future. Why wouldn't you? You know, absolutely. I've learned a huge amount from this. It's been great. I really appreciate it.
And I guess if anyone's listening and they're on the fence, they think, I don't know what advice is right for me, they can pick up the phone and just have a chat with you guys.
I do a 15-minute free consultation.
Cool.
There's no obligation. It's just a chat. I can't necessarily guarantee that I can help you at the end of it.
Mm-hmm.
That's the idea of the chat, just to see if it's something that I can do. So I can do that for anybody who has any issues around wills or inheritance or estate planning.
So just any questions about it before they move into the actual process.
Yeah, a sort of a pre-meeting as such.
We tend not to do that so often, just because for me to be able to give you a reasonable steer, I need to know so much about it that we're getting beyond
so
the
like a
15-minute
fact find
point.
at that point.
And I'm always a bit nervous about pointing someone in the wrong direction by accident. Not that I think you're not, but just there's such a variety of different situations. We would normally, I'm very happy to have a conversation with someone to see if they think that they could work with us, or if they've got a couple of burning questions. But usually what we'd offer is a meeting for a fixed price so that they can budget for that. And at the end of that hour-long meeting, someone should have a pretty good idea of their rights and obligations and options, and then they can go away and think about what option might work best for them, including doing nothing sometimes. We don't have to continue. But that's the aim, is to answer all of your questions. And for me to do that, I need to know a bit more about you than you might want to tell me in an initial conversation.
You'll get it out of them, Dianne, I'm sure. Okay, well, thank you. I mean, Dianne, Kimberley, it's been an absolute pleasure. As I say, we've learned so much from that. I think that's got to be our record for asking the most questions.
I know.
Can I ask you a question? What do you think stops people from taking the step to get advice before they purchase?
It's a great question.
I think it was just not having any clue, and then when we went through the purchase, our solicitor just kind of threw the information in as it was happening. So I think it's just not understanding what. I mean, I just don't have a legal background in any sense, and I'm sure like most of my friends are the same. It's just that not knowing what it is, and I think a lot of people also assume that I know a lot of people who speak about getting prenuptial agreements and then just think, oh no, it'll be fine, and then
it's not.
Yeah.
I think one of the things is that when people are buying a property, they want to be spending all their money on the new sofa and the nice curtains and all that kind of stuff, and they don't want to have to think about adding a will onto that or adding a prenup into that, because it's going to cost more money and they're going to have less money for the nice things for the house. But you know, definitely probably more important than the sofa, I would say.
Yeah, I think as you described today, I mean, certainly I'm just thinking back over my career and things I've done. I mean, many years I worked in sort of mortgage advice and worked with mortgage advisors, and advisor would bring these things up because you would do a fact find and you'd say, you know, and so the general response was like, okay, we'll do that another time, you know, and I think a lot of the time your main focus initially is just, let's just get the house. I just want to get, you know, I'm signing a lot of forms, I don't want to sign it, I can't really think about anything else. So there probably is a moment, as you say, things can change, that it's about revisiting these things. And hopefully, if nothing else from today's show, people think, actually, the time is now, it's doing it as early as possible, because it can save so much difficulty in the long run. And
I think as well, when you're buying a house, it's really stressful. I mean, no matter how good the support and advice you get from your mortgage advisor and your solicitor, I mean, I've purchased my own property and I know enough about it, and I was still stressed out of my mind on the day and running up to that. And so someone else comes and say, well, what would happen if you split up? You just don't want to have that conversation.
Oh, by the way, can you sign this or something?
So I can understand that, but I think the other takeaway is it's not too late to deal with it. I mean, you can, if you haven't done that before your purchase, but you think it would be a good idea to put it in place, or as we said, after the wedding, if you want a post-nuptial agreement, there's usually still scope to do that when things have calmed down a bit. Obviously, if you've already put in your life savings, you know, you're a little bit on the back foot, but if your partner is reasonable, which they are because they're your partner, you should still be able to negotiate it. So all is not lost. If you just haven't had the bandwidth or the money to deal with it beforehand, we can still have that conversation after.
Yeah, and the same goes for a will. You can make a will anytime.
Absolutely, yeah. That was the best question of the day, that.
Yeah.
But thank you. That's been really
Thank
great.
you
Thank you, Dianne. Thanks for coming. It's been, we've enjoyed it. Thank you. Well, there you go. I thought that was fantastic. I think that was arguably the most informative. I think we asked a lot of questions today, but we did an awful lot of listening.
We did, yeah. I think it's because death is something that affects everybody, and having a will is something that everyone should have. So if you're listening to this and you don't have a will, including myself, you need to get to a solicitor and get a will, because it just makes everything a bit easier.
It does, and I need to update mine because it's been more than 5 years and I need to tell people where it is. So yeah, we learnt a lot and we're going to take actions ourselves, and as we heard today, 61% of people don't. We learnt all about prenups and everything else in between. Just a really good episode.
Yeah, and if you enjoyed this episode, please remember to give us a like or a rate and review wherever you're listening.
Or leave us something in your will.
Well, yeah, we'd welcome that. And if you have any questions, please feel free to send us an email on marketing@espc.com. Otherwise, we'll be back in your ears next week.
Yeah, we will see you then. Thanks again for tuning in, and we'll speak to you soon. Bye-bye.
Bye.